everyone for being here. I'll start, in Australia, what we do, we start with an acknowledgement of country just for recognising the traditional owners of the place that we're meeting. Obviously, we're meeting from all over the world, but for me at least, I'm in Sydney, which is the traditional land of the Gadigal people of the Eora Nation, and I pay my respects to their elders past and present, and I obviously carry that on for other people as well, for everywhere they happen to be, and the panelists might like to do that if they'd like to, or not. Today, we've got an excellent group of speakers. As Wes has said, we've got Karen Drake, Associate Professor at Osgoode Hall Law School. We've got Kent McNeil, a Professor also at Osgoode Hall Law School. Tim Goodwin, a Barrister at the Victorian Bar, and Professor Kirsty Gover from the University of Melbourne, and a former co-chair of this interest group as well. It's certainly quite quick, just an hour, but I'm going to stick to 10 minutes for each presenter, and then we're going to have time for questions at the end. But because it's only short, I might just get straight into it. So if it's okay, Karen, would you like to begin?
Great, thank you. Ani, bonjour. Karen Drake in Chicaz. Wabagoni, Zagagon, Indonjaba. Toronto in the Nongum. So I'm a member of the Wabigoon Lake Ojibwe Nation, and I'm very grateful to be able to make my life and earn my livelihood in the territory of Mississaugas of the Credit First Nation, which is subject to the dish with one spoon wampum, and which is also known as Toronto, Canada. And that's where I'm speaking to you from today. So thank you very much to the organizers of this event for the invitation. And thank you very much to each of you for this opportunity to engage with you. My goal today is to provide you with a brief overview of the Supreme Court of Canada's decision in Desalto, including a few of the issues addressed by the court. And then I will turn it over to my colleague, Professor Kent McNeil, to discuss the remaining issues from Desalto. Okay, so what is this decision about? Well, it's about Mr. Desalto, who's a US citizen and who lives in the United States. So he's not a Canadian citizen. In October of 2010, he legally crossed the border from the US and entered into Canada, but he illegally shot an elk. So he was charged with 2 violations of British Columbia's Wildlife Act. He was charged with hunting without a license and with hunting big game while not being a resident. Now, Mr. Desalto admitted that his actions contravened the legislation, but he argued that he had an Aboriginal right protected by Section 35 of Canada's Constitution to do what he did. So what was the basis of his argument? Well, Mr. Desalto is a member of the Lakes tribe of the Colville Confederated Tribes, which is based in the state of Washington in the United States. And the Colville Confederated Tribes is a successor of the Sinixt Nation. And as of 1811, which was accepted at trial as the date of contact between the Sinixt and Europeans, as of that date, the territory of the Sinixt spanned what is now the Canada-US border. And the place where Mr. Desalto shot the elk in Canada was within the territory of the Sinixt. The trial judge held that over time, a constellation of factors forced the Sinixt to go from engaging in a seasonal round throughout their territory, including throughout Canada, to living primarily in the US portion of their territory. So one of the key issues in this decision was, can someone like Mr. Desalto, who's not a Canadian citizen and who does not reside in Canada, can someone like that exercise an Aboriginal right that's protected by Section 35 sub 1 of Canada's Constitution? So Section 35 is the provision of our Constitution that gives constitutional protection to Aboriginal rights and to treaty rights. The text of Section 35 says specifically that the existing Aboriginal and treaty rights of the Aboriginal peoples of Canada are hereby recognized and affirmed. So that's it. That's the whole text of Section 35 sub 1. The key here is this phrase, the Aboriginal peoples of Canada. The question is, can this phrase include Aboriginal peoples who are located outside of Canada? So the lower courts throughout answered the question in the affirmative. Yes, they can. And they acquitted Mr. Desalto. And the majority of the Supreme Court upheld these decisions. We have a dissent, though, from Justice Cote, and also a dissent from Justice Moldaver. So let's talk about, though, how the majority reached their conclusion. So first, the majority held that this question, namely whether an Aboriginal people can be an Aboriginal people of Canada, even if they're located outside of Canada, they held that this is a threshold question. In other words, this question must be answered first, and only if an Aboriginal people pass this threshold can they go on then to apply the test for whether they can assert an Aboriginal right. So this is one point on which the majority and the dissent actually agreed. And this is one point on which Mr. Desalto lost. So he was arguing the contrary. He was arguing that there should be no new threshold issue here, that really just the test that already exists for Aboriginal rights should be applied, and that that should provide a full answer as to whether he can exercise an Aboriginal right. So arguably, there's a sense in which the majority has created a new hurdle that Aboriginal peoples have to overcome. It's important to recognize, though, that this threshold question is actually quite limited. So this hurdle is actually a very narrow hurdle. The threshold question is not whether an Aboriginal people asserting a Section 35 right are Aboriginal, nor is the threshold question whether the people asserting the right are a people. Neither of those two things were at issue in this decision. Instead, the threshold is merely whether the Aboriginal people asserting the right are an Aboriginal people of Canada. That was the only issue that was at play here. And we can see a number of Justice Rowe's statements. Justice Rowe is writing for the majority. We can see a number of his statements confirming the very narrow nature of this threshold question. So he says that this question should not be construed as an additional burden on Aboriginal claimants to be satisfied in every case. And instead, the issue will only arise and need to be addressed in very specific situations, such as when the group is specifically located outside of Canada. Okay, so how did the court reach the decision that the phrase Aboriginal peoples of Canada includes Aboriginal peoples located outside of Canada? The answer is that it used a purposive analysis. Now, the Supreme Court of Canada has been using a purposive approach in interpreting Section 35 for as long as there has been Section 35 jurisprudence. And the purpose of Section 35 was explicitly identified most articulately in the Vanderpeet decision. And here the court articulated a twofold purpose for Section 35. The court said that the purpose is first to recognize the fact that before Europeans arrived in North America, Aboriginal peoples were already here occupying their land. And second, the purpose is to reconcile this fact, the fact of Aboriginal prior occupation, with the Crown's assertion of sovereignty over Aboriginal peoples' territories. So the majority says that the answer to our overarching question can be deduced from this twofold purpose, and more specifically that the Aboriginal peoples of Canada under Section 35 are the modern successors of those Aboriginal societies that occupied Canadian territory at the time of European contact. And so that this can include Aboriginal peoples that are now outside of Canada. So in terms of applying this reasoning to this decision, the majority of the Supreme Court noted that the trial judge found as a fact that the Sinixt had occupied territory in what is now British Columbia, Canada, at the time of European contact, and that the trial judge also found that the Lakes tribe are a modern successor of the Sinixt. Therefore, the Lakes tribe are an Aboriginal people of Canada, even though they're located in the US. Now, Justice Rowe provided a number of additional rationales in support of this purposive interpretation. Now, given the constraints of time, I won't go through all of these. In fact, it looks like I only have perhaps a minute or two remaining of my short 10 minutes. And so I think I'm going to skip through to a couple of other issues that have been assigned to me as opposed to my colleague, Professor McNeil. So one of the issues that arose are, what are the consequences that follow from Aboriginal peoples located outside of Canada being able to assert and exercise Aboriginal rights within Canada? The Crown and several attorneys general raised concerns about the possible consequences of this. The majority, though, was not concerned about these potential practical consequences. The majority said that there's no need for a different set of laws for Aboriginal peoples who are outside of Canada as compared to the law that we already have, the jurisprudence we already have that applies to Aboriginal peoples within Canada. That the test is the same for both when it comes to establishing an Aboriginal right. The majority did say, though, that the different circumstances of each may lead to different results. The law, though, is the same. Now, one more issue that I will very briefly touch on is that this case arises from a prosecution of a regulatory offense. And the Supreme Court of Canada has already recognized the pitfalls of attempting to resolve Aboriginal rights issues and to achieve reconciliation in the context of the prosecution of criminal or quasi-criminal offenses. And the majority in this decision emphasizes this point again. Now, I want to mention this just briefly because my colleague Kent McNeil has written a case comment along with Kerry Wilkins on this decision. And they make the very important point in their case comment that even though the court continues to exhort Aboriginal peoples to pursue Aboriginal rights claims in a civil context as opposed to within prosecution of a regulatory offense, that the prosecution of regulatory offenses continues to be a prominent means by which Aboriginal peoples assert their rights. And they identify two reasons for this. First, they point out many different ways in which the courts have actually restricted Aboriginal people's ability to make use of civil proceedings. They also note the huge expense, cost, and time investment required in civil proceedings. And so they make the very important point, I think, that the court is creating a kind of paradox or catch-22 by attempting to exhort Aboriginal peoples to use civil proceedings and yet making it much more difficult for them to do so. So with that, I'll turn it over to my colleague, Professor Kent McNeil, who will discuss a number of other issues raised in Desalto. So Miigwech, thank you.
Okay, well, thank you very much, Karen. You've made my job much easier by setting out the facts and the main issues in the case and so on. I'm speaking to you from the Six Nations territory in Southern Ontario, the Haudenosaunee, and so I would like to acknowledge that. It was also traditionally the territory of the Mississaugas. So I'm going to address three issues arising out of the case. And it's interesting, in this case, the Supreme Court mentioned a number of issues and arguments that were raised without going into much detail on them and without resolving them. But one issue that I'm going to talk about that is important that was resolved is the issue of continuity. I'm also going to talk about common law Aboriginal rights, which may be different from Section 35 Aboriginal rights. And then the third issue is sovereign incompatibility, which the dissent was more concerned about than the majority. So starting with continuity, there was no evidence in this case that the Sinix people had actually hunted in British Columbia from about 1930 up till 2010 when Mr. Desalto killed the elk. So there's an 80-year gap there. And so the question arose, I guess argued by the Crown, well, they may have had an Aboriginal right at one time, but now they live in the United States and they haven't hunted in Canada for 80 years. And therefore, they can't sort of revive a right. The dissent, well, there were two dissenting judgments on this, but Justice Cote in particular said, you can't revive a right with one shot, right? And so the majority addressed this issue, and I had thought that this issue had already been resolved by the Supreme Court. But given the dissents in this case, I guess it hadn't been. So the majority, I think, followed what I took to be the law, which is once Indigenous people establish an Aboriginal right, according to the Vanderpeet test, which they have to show that it was based on a practice, custom, or tradition that was integral to their distinctive society at the time of contact with Europeans. And the court took that to have happened in 1811 for this particular Indigenous nation. So once the right is established, then the Supreme Court has said in the past, starting with Sparrow in 1990, that then the onus shifts to the Crown to try and prove extinguishment if they want. In other words, the right is there. It's up to the Crown to prove extinguishment. In other words, it doesn't get lost through non-user. However, the dissent in this case thought it had been lost through non-user because of this 80-year gap. Well, that's just inconsistent with the common law. So the court doesn't go into this, the majority doesn't go into it in a great deal of detail. But the fact is that one doesn't lose rights at common law just by not exercising them. And there's a series of English cases involving customary rights. And in particular, one judgment by Lord Denning involving a customary right to use or to hold a fair in a village. And Lord Denning said, this can't be lost through non-user. How could some of the people who have it? So it's important that that is a collective right, like the Aboriginal rights we're talking about here. He said, how can some people, lose it for others by not using it? Or how can one generation lose it for future generations? And that's very similar to the Indigenous situation. So there's, strong authority going back to, the English common law to support the position of the majority. So that's the continuity issue. And, thankfully, the majority decided it the way they did. I know for you Australians, probably thinking of the Yorta case. And so fortunately, Canada has gone in the other direction on this, right? And we now have affirmation of that from the majority. Okay, common law Aboriginal rights, the second issue. So the Crown argued that maybe Mr. Desalto had a common law right to hunt in Canada, but it's not a Section 35 right. And well, what's the distinction here? Well, as I said, to be a Section 35 right, the Supreme Court has said that it has to be based on a practice, custom, or tradition integral to the distinctive society at the time of contact with Europeans. Now, Indigenous peoples had their own political systems and their own laws and rights under those laws. And those rights should have continued upon Crown assertion of sovereignty. And the Supreme Court has actually acknowledged that in other cases. And the majority, and just briefly, refers to that fact. So that's based on the doctrine of continuity. In other words, when a new sovereign takes over a territory, pre-existing rights under the previous sovereign continue, and those become enforceable in the common law courts. And that's what the court is referring to when they talk about common law Aboriginal rights. They're talking about rights that existed prior to Crown sovereignty and continued thereafter, but they're not necessarily Section 35 rights because they're not necessarily integral to distinctive Indigenous societies. So we have this distinction here between possible common law Aboriginal rights on the one hand, and other rights that may be derived from common law Aboriginal rights, but also have Section 35 protection. Now, as I said, the court doesn't elaborate on this. It refers to it. And so, but I think there's some really interesting possibilities here, because up till now, I think the view is pretty much been, well, if you don't have Section 35 Aboriginal right, you don't have an Aboriginal right. But now we have a possibility of utilizing the doctrine of continuity in more creative ways. So I see that as a positive development. Okay, the third issue is sovereign incompatibility. And again, the minority, in particular, Judge Justice Cote, was concerned about this because she was concerned that if Mr. Desalto had an Aboriginal right to hunt in Canada, then maybe he has a right to enter Canada, even though he isn't a Canadian citizen. Now, he entered, I think as Karen pointed out, he entered Canada legally. Okay, he arrived at the border, coming in as a foreigner, enters legally, and he wasn't claiming an Aboriginal right to enter Canada. He only claimed an Aboriginal right to hunt once he got within Canada. So the Supreme Court wasn't too concerned about this because the issue didn't really arise on the facts. But the minority was concerned about it. And they said, well, if he has an Aboriginal right to hunt in Canada, then doesn't he have sort of an incidental right to enter Canada? And that's a problem because a major part of sovereignty is control of borders and who can enter and who can't enter. So, that issue, the minority, the dissent pointed out as well, could come up around Aboriginal title. How much time have I got here? I just have lost track. I haven't been looking. No, someone? 1 minute.
Just 1 minute, sorry.
Okay, I can wind up in 1 minute. That's good. So, yeah, the issue of Aboriginal title was also raised. And so if Aboriginal groups outside Canada can have Aboriginal rights to hunt, then they might have Aboriginal title to land as well. And that opens up a lot of possibilities. And in fact, the Sinix Nation itself has an Aboriginal title claim in Canada that was raised in one case. There were issues there around standing and so on, but they won't be the only ones. The fact is, this international border was drawn, in basically 3 international treaties between Britain and the United States. In 1783, in 1819, and then in 1845. No, 1818, I think. Anyway, the one we're concerned about here is the one that drew it between what's now Washington State and British Columbia. That was the Oregon Boundary Treaty of 1846, and that's what the court relies on for acquisition of Crown sovereignty. So, this international boundary divided many Indigenous nations across North America. So we're going to have this issue arising elsewhere, but it also brings in the bigger issue about Crown sovereignty, which the Supreme Court never questions. They don't want to get into that. But there are serious issues around Crown sovereignty, pre-existing Indigenous sovereignty that the Crown has acknowledged. And so how can the Crown get sovereignty without treaties or cession or conquest when Indigenous peoples already had sovereignty? So as I say, that issue isn't addressed at all in this case, but it's out there. It's out there, and there's a lot of discussion about it in Canada. Okay, I'll close there. Thank you.
Thanks, Kent, and thanks, Karen. I think Tim is going to speak now, and I just know there's a lot of the similar anxieties in the High Court in the Love Tom's case as well about control of borders and sovereignty and these sorts of things. And I know Tim and Kirsty will speak about that and I guess connect Love Tom's with Desalto. So thank you, Tim.
Thanks, Harry, and yes, thanks, Kent. You've despite being on the other side of the world, you've linked perfectly and set up a really good discussion of Love and Toms to follow on from that last point that you made. Thank you for having me, everyone. And can I acknowledge traditional owners of the country on which I'm located, the Wurundjeri and Bunurong peoples of the Kulin Nation. Pay my respects to them as a member of the Yuin people from the south coast of New South Wales. And I pay my respects to all traditional owners of the lands upon which everyone is located, and pay respects to my fellow Indigenous brothers and sisters and others who are here today. The Love and the case I'm talking about is called Love and Commonwealth, but we often call it Love and Toms because there were two plaintiffs involved in the case. The background to the case is that the power to deport someone in Australia flows from the Migration Act, or is contained in the Migration Act, which is a Commonwealth, a federal government piece of legislation, which is reliant on a particular head of power under our Constitution, as all Commonwealth legislation has to be. And in particular, the power to deport someone under the Migration Act is reliant on the alien's head of power. So to fall within the power to deport, someone has to be an alien for purposes of our Constitution. The migration, there is a mandatory application of a visa in circumstances where someone fails what is called the character test. There are various ways someone can fail the character test. The primary method is usually that someone has been sentenced to a term of imprisonment of more than 12 months. Mr. Love and Mr. Toms both failed the character test for the purposes of the Migration Act, and both were non-citizens, but also Aboriginal Australians. Mr. Love is a citizen of Papua New Guinea, but has lived most of his life in Australia. And Mr. Toms is a citizen of New Zealand, but has also lived in Australia for most of his life, and is also a recognised native title holder under a native title settlement between his particular Aboriginal nation, as recognised by the courts. So the question was whether Mr. Love and Mr. Toms were aliens for the purposes of the Constitution by reason of them being non-citizen Aboriginal Australians. There was an original argument heard in May of 2019, in which the plaintiffs attempted to argue on relatively narrow grounds that as Aboriginal people who were born to an Australian citizen and had lived a majority of their lives and continued to live their lives in Australia, that they weren't aliens for the purposes of the Constitution. But at the hearing, the court was much more interested in the broader issue of whether Aboriginal Australians at all could be aliens for the purposes of the Constitution. The court reserved, and at that point only the Commonwealth had appeared as the respondent to the plaintiff's case. But a number of months later, a supplementary question was sent to the parties, and also went at that point to all states and territories who have the immediate right to intervene in any constitutional law question before the High Court. The supplementary question asked whether the recognition of native title by the common law of Australia recognised a corresponding permanent duty of allegiance by Aboriginal people to the Crown, and whether the Crown owed a corresponding permanent duty to protect Aboriginal Australians. And because core to the concept of non-alienage is the idea of allegiance, that on that basis, Aboriginal Australians could not be aliens for the purposes of the Constitution. Now, it was at that point that the state of Victoria, who I was General Counsel for, decided to intervene in a second hearing of the matter, because the state of Victoria is the most progressed state in Australia in negotiating a modern treaty with its citizens, with Aboriginal Victorians. And the concern of Victoria was that if the High Court recognised by majority a permanent duty of allegiance to the Crown, that it may somehow impede the state of Victoria's capacity to negotiate the particular relationship it had with Aboriginal Victorians by right of the Crown, which in Australian law has different emanations: the Crown by right of Victoria, the Crown by right of the Commonwealth, the Crown by right of New South Wales, but is one whole at the same time. And so Victoria was worried that recognising a particular relationship between Aboriginal people and the Crown would somehow potentially impede its negotiation process of a treaty. So in a rare circumstance for a government in Australia, it intervened on the side of the plaintiff rather than the Commonwealth or the government or the government in any shape or form, and argued that Aboriginal Australians are not aliens because, as members of an Aboriginal society, they have a recognised mutual and unique relationship with the land and waters of Australia. So this relationship is built on the same foundations of citizenship. The etymology of an alien means to not belong to a place or a people. And so the state of Victoria argued that Aboriginal people, as Aboriginal people, have a particular relationship to the land and waters, one built on mutuality and reciprocity, that means they belong to that place and the land belongs to them, in that notion of a reciprocal relationship. And so that therefore they could not be alien to Australia because they inherently belong to Australia. The state of Victoria also took the approach that despite needing to be a member of an Aboriginal society to build that relationship, which comes from the concept of native title, an Aboriginal person did not need to establish native title to be a non-alien, because whether or not the common law recognised their particular relationship to particular land, they, by being Aboriginal, had that form of relationship, whether or not the common law recognised it, and whether or not they subjectively knew where their particular relationship to land was. Because as an Aboriginal Australian, by definition, they had a relationship with some form of part of Australia, and so could not be alien to Australia. In a 4-3 decision, the High Court held that Aboriginal Australians were not aliens for the purposes of our Constitution. Justice Nettle, it turned out, was the judge who relied on the idea of permanent allegiance, but was the only one to do so. For Canadians in the audience, he was clear that he was not recognising a fiduciary type of relationship, even though I'm sure if my Canadian friends read the judgment, they might wonder why. But that's an interesting footnote to his particular decision. The other three in the majority took a relatively broader view. Justice Bell stated simply that Aboriginal Australians were a sui generis category and therefore were non-aliens by reason of their relationship to the land and waters of Australia. Justice Gordon focused on the concept of belonging and that native title had recognised that belonging to land and connection to land, and on that basis Aboriginal Australians could not be alien. And Justice Edelman focused on the idea that Aboriginal people were permanent members of the political community by reason of their sense of belonging to land. Interestingly, and this is to Kent's last point, all of the judges, both in the majority and the minority, made very clear that they were not questioning the acquisition of British sovereignty or recognising some form of Aboriginal sovereignty by reason of recognising that Aboriginal people were not aliens. Just as a final note, because the four majority judges had different reasoning by which they came to their decision, they stated at least that all of them agreed that Aboriginal Australians, according to the tripartite test set out in Mabo number 2, the seminal decision that recognised native title in Australia, that those people could not be Aboriginal Australians. On that basis, Mr. Toms clearly fell within the definition of Aboriginal Australian as he was a native title holder. There was a dispute as to whether Mr. Love, as a factual matter, was an Aboriginal Australian because he had only been recognised, the tripartite test being descent, self-identification and community recognition. Because he had only been recognised by one elder of his particular nation, there was a factual dispute about whether that was sufficient to meet the third limb of the tripartite test, namely community recognition. And so his case was sent back to the lower courts, our federal court, for determination on that factual matter. And as a probably foreseeable consequence of the decision, but one that wasn't the focus of the hearing or really any of the judgments, is that now there are a number of cases making their way through the federal courts on whether a person either being held in immigration detention or who may be in the community but is at risk of losing their visa and therefore being deported are in fact Aboriginal Australians, which is a factual matter to be determined by the courts. And it's raising interesting questions about the application of the tripartite test. But I'll leave it there. Thanks, Harry, and thanks, everyone.
Thanks very much, Tim. Kirsty.
Well, thanks everyone for hosting me. It's a real pleasure to see everyone and to see some old friends here as well. I'll also like to start by acknowledging that I'm on the lands of the Wurundjeri people of the Kulin Nation, and also I'd like to pay my respects to the Kati Mamwe Ngāi Tahu people of Aotearoa, New Zealand, on whose traditional land I was born and raised. This has been a fascinating panel for me. I've learned a lot. As we've heard, there are several loose ends attached to each of the two cases we've been discussing. And hopefully these will be tied up by lower courts or law reform in a way that protects Indigenous rights. And I suppose that I hope when any of this happens, that decision makers might draw on principles established in international and regional human rights jurisprudence. And that's the connection I want to focus on in these concluding thoughts. So I thought I might try to round off the discussion by drawing attention to some of the implications for international law and vice versa of these unresolved questions by connecting them to two bodies of international human rights law in the inter-American and UN human rights system, revolving around the right to enter one's own country. So of course, first, these two cases put pressure, as Kent noted, on the immigration laws of settler states. They revolve around a right to remain in the territory of a state where one's traditional land is located, but neither case expressly addresses the question of what happens at the border. And in both cases, the right of the applicants to enter the state is not in question, but in some cases, of course, it will be. And this connects directly, I think, to the possibility that international law may be required to turn its attention to this question when and if traditional owners are prevented from accessing their traditional land because they're prevented from entering the state whose boundaries enclose it. So going to the jurisprudence of the Inter-American Court of Human Rights, and all of you will know, I think, that this court has generated a very progressive line of reasoning on Indigenous land rights. It's really at the forefront of thinking about the ways that human rights regimes can be adapted to the special circumstances of Indigenous people. And the court has done this relevantly by applying the property protection in the American Convention on Human Rights to include Indigenous ancestral connections to land, and to protect connections that are not dependent on continuous or current occupation, or of course on state recognised property rights to the land in question. So the property protection has been extended by the Inter-American Court to protect the spiritual and cultural relationship of Indigenous peoples to their traditional lands. And significantly for today's discussion, I think, it's found that the Convention protects this relationship even when the Indigenous community no longer possesses or has access to their traditional territory, and even when that exclusion has been of an intergenerational duration. And in the course of developing this jurisprudence, the court has also recognised that Indigenous peoples have the right to return to their ancestral lands as an expression of their right to freedom of movement and residence. This Indigenous right of return to traditional lands was recognised and discussed in the 2005 case of Moiwana Village and Suriname. And there the questions were about movement within the state boundaries, so international borders were not implicated in that decision. But in elaborating on this right, the court did refer to the UN's own standards on the right to enter one's own country. Now, this is a protection found in the ICCPR, the International Covenant on Civil and Political Rights, in Article 12. Now, significantly, the Human Rights Committee, on its jurisprudence on Article 12, has held that the right to enter one's own country is not confined to nationals. And in its general comment on that article, it has noted that, quote, there are factors other than nationality which may establish close and enduring connections between a person and a country, connections that may be stronger than those of nationality. And this would include, they have said, at the very least, an individual who, because of his or her special ties to or claims in relation to a given country, cannot be considered to be a mere alien. So non-citizen, non-national Indigenous persons seeking to remain within a state in order to exercise their rights to return to traditional land, they seem to be excellent candidates for such a status. And the domestic law expressed in these two cases seems to put this distinctive status into practice. And to me, this raises the possibility that international law itself may be pressed to move towards recognising this distinctive status of non-citizen, non-national Indigenous people, and especially if petitions are put forward by Indigenous persons who have been denied entry to states. Now, one would hope, or at least I hope, that the requisite connection in such cases could be understood by human rights bodies as one not necessarily tied to an extant community and its social characteristics, as per the famous Notabone case, but perhaps as one where the relevant connection is to the land itself. And this, I think, would be an approach that accords quite closely with what I at least understand to be principles of Indigenous law and legal traditions about the connection between people and place. And it could be a very significant development in international law if that were to be expressed by one of the treaty bodies. And finally, as a concluding thought, again with an eye on international law, perhaps we might think that these two cases, combined with the vector of the inter-American courts jurisprudence, show us the persistent normative power of Indigenous law and Indigenous boundaries, both human and territorial, and show us that they have survived the superimposition of the international order of states across them. And perhaps this collection of norms, partly domestic law of settler states, partly international law, definitely not unified yet by a single theory, but perhaps they could come together as a step towards the recognition of an underlying and pre-existing international order of Indigenous peoples, which shows the state order as contingent and the underlying order as the more permanent of the two. And if this is to be the way that this body of law, which is very nascent, develops, then we will have to return, as Tim has very eloquently just explained, to the baseline of Indigenous law, and especially Indigenous law of membership and the laws that govern the self-constitution of Indigenous groups. And these cases show us, I think, that this body of law is legally cognizable in the law of settler states, but it's not wholly determined by that law. And so they helpfully show that there are limits to the state's power to interfere in Indigenous self-constitution. There are limits to the state's power to regulate Indigenous connections to land. And noting that these limits are located in the constitutions of settler states as a sort of self-limitation, perhaps, on sovereign powers. And all of these ideas, I think, are enormously interesting, very, very complicated, but point to something that could be transformative internationally and domestically. Thanks all. That's the end of my talk.
Thanks, Kirsty. I think it's really, really excellent. All four presenters really enjoyed your comments. We have a little bit of time if anyone would like to have a response to any comment that has been raised. I think, Kent, you've unmuted yourself. Would you like to say something?
Sorry?
Sorry, I saw you've unmuted yourself. I was just saying there's a bit of time.
Oh, no, I just did that, so I'm joining the conversation. I don't have a question.
No trouble. Did anyone have anything they wanted to respond to, anything that they'd heard? Karen, perhaps as you went first, or you're okay?
I don't, but thanks for asking.
No trouble. So we have a bit of time for questions, so please put responses in the Q&A. I might just go first, if that's okay. That's the best thing to be as moderator and set up a panel that you wanted to hear about and be able to have the first crack. My response, I guess, is maybe thinking more about the politics of these decisions and just the way that they can create anxieties within some members of the community. And I know a little bit about what's happened in response to the Love Tom's case in Australia, but I'd like to hear from Karen and Kent about the political reaction to the Desalto case. Has there been a response? In Love Tom's, at least, there was a big concern among members of the government that this was a judicial activism, and they needed to make sure that they would replace judges with capital C conservative judges who wouldn't make such a decision again. Has there been a similar response to the Desalto case in Canada?
Karen, do you want to go ahead?
You can go ahead, Kent.
Well, not that I'm aware of, but I'm not very tuned into what's happening politically. But I don't think it was a big enough issue for the Canadian government to be too concerned about the result. I mean, I could be wrong about that. I don't know what the Department of Justice lawyers are saying and so on, but I think certainly the federal government, well, the provinces too, they've got too many other things to deal with right now.
That was my sense.
Right, Karen?
Yeah, I concur. My sense was that it barely made a ripple on public consciousness, really.
Yeah, interesting. Okay, sorry.
No, sorry, Harry. I was going to react to that, which is interesting because, I mean, if you know anything about Australia, border politics have been prominent for 20 years now, and probably before, but particularly the last 20 years. And so any concern about the weakening of borders definitely creates a reaction amongst our federal government in particular. And so two of the judges in the majority in the Love case have since retired at their mandatory age of retirement in Australia under our constitution for federal judges. And so they've been replaced by two new judges. And part of the reason why there are a number of cases being fought and contested quite heavily in the lower courts is because I think many of us think the federal government want to get back in the High Court and attempt to test whether Love and Toms can be overruled. And there's some good precedent for that, because at one point in the I'm going to be embarrassing and forget if it was in the 1990s or in the early 2000s, there was a very short period of time within which the High Court recognised a category of non-citizen, non-alien, because since the passage of the Citizenship Act in the 1940s, the concept of non-alienage has been equated with citizenship. And that was that was a series of precedent that actually Love and Toms needed to get around. There was a short period where the High Court did recognise a category of non-citizen, non-alien, but that was shut down by a subsequent High Court only a number of years after a particular decision. So I think the federal government thinks that if it gets back in the High Court, it could reopen the question of the correctness of Love and Toms, particularly now there are two new judges on the court. So it's an interesting question, and one it's going to come up again, I think. And the way to get there has been that the government is taking a very narrow approach to the question of who is an Aboriginal Australian by reason of the decision. So there are a number of interesting cases, as I said, making their way through the federal courts on that question. I think Kirsty had a hand up.
Yeah, Kirsty, sorry. Thanks, Tim.
Yeah, is it okay if I ask a question, Harry?
Yeah, of course. There's a couple of the Q&A as well, but I think...
let's do those first. I don't want anyone to miss out.
Sorry, can you see them as well, or should I read them out?
I am not sure. Let me look.
We've got a comment by Peter Willis talking about the COVID-19 restrictions on international travel, providing a concerning backdrop to your propositions about right to return. And then the comments from an anonymous attendee and from Alan talking about the residential schools. The residential schools, the awful news in the last couple of weeks about the finding of mass graves at residential schools and international human rights concerns. And then also about, I guess, inter-Indigenous claims to territory. And I think they're sort of both interesting, both maybe not directly relevant to this point, but if anyone wants to raise anything here, or Kirsty, if you'd like to ask your question, we've got to conclude soon, sorry.
If it's okay, I mean, I was fascinated, Karen, by the way that you explained the case, and this question might go to you or to Kent. So as I understand it, the Sinkt people moved south into another part of their traditional territory across the border and joined an existing group of people there, which we now know of as the Lakes tribe. And I never thought of it in this way until I heard you speak, but if that Lakes tribe, now a federally recognised US tribe, is now an Aboriginal people of Canada, does that include everybody who was already there? Assuming it's now integrated, some people moving south and some people who are already resident there. Does that mean that all members of the Lakes tribe are now part of an Aboriginal peoples of Canada? Am I understanding that correctly?
I think it's somewhat different, but Kent, perhaps you can jump in as well. My understanding is that the Sinaiaks people initially have a territory that spans, the Canada-US border, and they travel a seasonal round throughout it. And then over time, they themselves simply live more permanently in the US due to things like the border being imposed. So it's not that they joined another existing group, it's just that they over time only used part of their territory, and for a period of time just didn't use the part of their territory that was in Canada. So it's not that they simply identified with another name, basically, and that's not uncommon for Indigenous peoples in Canada to have different labels being applied to them throughout time, or to be dissected into subgroups and have different labels attached to the subgroups, whereas the Sinixt Nation can be thought of as the overarching nation, and the Lakes Tribe is one people or community within that nation.
That's very helpful, and my apologies for mispronouncing the name of the Sinixt people.
I'm not 100% on that. I got that from Googling it, so I hope I'm pronouncing it closely at least.
Very helpful, thank you.
And maybe I could just add that not all the Sinixt people are members of the Lakes Tribe. So there are serious issues here around sort of the rights holding group. But the Supreme Court didn't really get into it because they were satisfied that current members of the Lakes Tribe, and certainly Mr. Desalto himself, were members of that, were at least, descendants from that original nation. But there are issues out there that have not been determined around that.
Thanks, Karen, and thanks, Kent. We've come to the hour mark, and so I have to thank everyone, thank all our presenters for their excellent contributions, and thank you for the attendees. I'm sorry we couldn't get to all of your questions, but I think I'm sure all of the panelists would be very happy for you to reach out to them at some point if you have more to discuss. You could also reach out to me, and then I could talk to them as well. We get back to you. But I want to thank you again for everyone, particularly Kirsty and Tim for turning up at 7 a.m. But Karen and Kent as well, thank you so much. And that concludes our event. So thank you so much, everyone.